Hey guys, Dr. Brandon Crawford here. I'm the founder of the Austin Center for Developing Minds. We are located just north of Austin, Texas in Cedar Park. And what we do is we focus on developmental functional neurology. Hopefully you'll have a chance to catch my lecture because I'm going to be taking you through what that process looks like and why it's so important to focus on rehabbing the brain in the right way, at the right time, with the right frequency and oscillations and all this kind of stuff, right? So I'm very honored to be a part of this conference. This conference is very meaningful. I love all the people involved, and obviously the cause is fantastic. So thank you again, and I look forward to seeing you soon.
At Cook Children's, we know if we work together, we can keep each other healthy.
Wearing a mask keeps droplets from your nose and mouth trapped so you don't spread viruses to others.
Wear a mask when you're going to be around people outside of your immediate family.
Avoid large gatherings and wash your hands a lot.
These simple steps can limit the spread of viruses.
Let's all do our part to keep our community healthy.
Good afternoon. Just wanted to thank you for having me here today, and also thank Rhonda Johnson of Team Loop Hope for Minds for inviting me for this presentation. My name is Boyd Hanley. I'm a solo practitioner in the Katy Fulsh area. I deal with probate, estate planning, wills, special needs trust, guardianships, elder law, and SSI and Medicaid. I'm also a proud parent of a young lady, 26-year-old young lady who we have guardianship of. So I've been in the same situation a lot of you have been in with a child with special needs and growing up and hitting the roadblocks that we deal with when we have one of these young ladies or young men with us. We'll be talking today about guardianship. What is it? When do I need it? We're going to go from start to finish about guardianship and some other issues in between if we have time. Unfortunately, I have to give you this disclaimer. There's no attorney-client relationship formed during this information time. I'm giving no legal advice. I'm giving you information that you can use. I also want to remind you that each person's situation is very unique and that there's many ways to fix issues or problems. So even though I may be giving you a lot of information today, there could be other ways to fix the issue that you may have. Okay, I also talk about a special needs toolkit. We're going to be talking about the left-hand portion of that toolkit today. Going over guardianship and the alternatives to guardianship. The special needs toolkit includes a lot of things. A lot is the team. You have your attorney, you have your specialists who deal with your child, and also your support team. And it's very important to have those things involved in it. As I mentioned, we're going to go over the alternatives to guardianship, which is required by law before we can proceed with the guardianship, and then we'll go over the steps of the guardianship. Why do you need a guardianship or alternatives guardianship? Well, in Texas, when your child turns the age of 18, he's an adult, he or she is an adult. And without either supported decision-making agreements or alternatives to guardianship, you cannot help your child like you did the day before they turned 18, because now they're adults and they all fall under the confidentiality of being an adult. I use this practical analysis a lot in my practice. It's put out by the American Bar Association, and whenever someone comes into my office asking about guardianship, I presume that guardianship is not needed. And then we actually go through the various steps on the alternatives to guardianship, what could be used instead of going through guardianship and taking away the young adults' rights. In 2015, the Texas legislature made some major changes in guardianship. They passed two bills, one with the alternatives to guardianship. And basically what they told the attorneys in the area that work with guardianships and the guardianship agencies that you really need to have to scrutinize the alternatives to guardianship to see if anything will work before you file guardianship on your young adult or possibly older person. They also passed in the same year was a supported decision-making agreement, which is in the code also. And this agreement, which we'll go over later in the presentation, will give parents or guardians, or not guardians, but parents or friends, the ability to go with your young adult with special needs or disability to meetings and explain to them what's going on where they can make a decision. There's a couple of different types of guardianships in Texas. The guardianship of the person, which I deal a lot with that when the young kids with disabilities are turning 18. They don't have an estate. So basically we go into the court with a guardianship of the person. That can be full or partial or limited. There's also guardianship of the state. That usually comes in with elderly people that are going through the guardianship process, where they may have a home or bank accounts or things of that nature. The other way that comes into focus is if apparently parent suddenly dies and leaves their minor child or child with a disability with a life insurance policy or a retirement fund. Unfortunately, in Texas, if a child is under the age of 18, they're still a minor and they cannot inherit property or things such as a life insurance policy without having someone to look after them. Most cases in the life insurance companies will require that parent to go to court, to probate court, and get a guardianship of the estate in order for the life insurance company to hand over the money to the minor or to the trust that would be set up. So we're really telling parents is if they've got a minor child, have a testamentary trust in their will that these assets are named to. I did talk about a little bit about the guardianship of the estate. That's with older people that do have estates or bank accounts. And again, that can be full or partial. And then you can combine the two and have guardianship of the person and the estate. We also have temporary guardianship if maybe an elderly person goes into the hospital and is incapacitated for a period of time, then their loved ones can come in and get temporary guardianship in order to be able to pay the bills and things of that nature. What is the difference between full and partial? Well, the good thing about Texas is that if you can take or choose what rights are taken away from the child. And also, guardianship is not permanent. I had the pleasure of sitting in on one of the courts a couple of years ago when the courts all changed judges, and I was sitting in on the new judges' guardianship proceedings to see how they would conduct themselves. We had a young man that was nonverbal. I was actually sitting next to him waiting on the court to start in the hallway, and he came up with his little machine and asked me a question. And of course, I told him the answer to that question. And then I was very proud to see that he was getting his guardianship returned to him. He had gone to HCC and got a computer science degree, and he was at a point where he could go out and work with some of the alternatives to guardianship, and he did not need guardianship. So, you know, if we get guardianship for your children now, and then later in life, they learn or to deal with their disability or able to cope more in the real world, then we can always go back to court and give those rights back to them. The full rights, I won't read them all, but they're in the bottom of the slide there, such as public election, able to drive, vote, and other things. What is guardianship of the person? Well, really, guardianship of the person is everything that you're doing for your child before they turned 18. It's something that just unfortunately, when they turn 18, that they're adults, and we have to go through that and get guardianship for our children in order to continue to look after them as they progress as an adult. In many cases, this particular guardianship of the person does not deal with an estate, but the courts still charge a $25 to $50 minimum with everyone. But you can look at those, and basically once a year, the guardians have to report to the court on their child. Guardianship of the state, I mentioned that before, but it's basically dealing with a person that maybe has a home or has bank accounts or retirement funds and all of that. A lot more is involved in that. We have a lot of parents that ask me, why don't we just go ahead and get guardianship for the person in a state for my young person? Well, one of the reasons is that you have to do a financial bond for the estate. You also have to, within 30 days, report what is in the estate. So there's a lot more reporting that's involved. And it's just really not feasible for a young person that doesn't have an estate to go into this type of guardianship. What are the guardianship steps? Well, in Texas, we can file 180 days or approximately 6 months prior to the 18th birthday. I tell a lot of my clients to start thinking about it about 8 months, because we also have to have a physician certificate signed. And that basically deals with how the disability affects the young person's day-to-day life. It also has a spot for any intellectual disability that the child may have. Normally, we can file that within 100 days of the filing date of the petition. But in most cases, I try to get that at the same time, because in our guardianship applications, we do talk about the physician's directive. One of the odd things that happens to you once you file a application is that a sheriff's constable will come by and serve your young person a citation. That's kind of scary when you have a sheriff's constable knocking on your door and asking for your disabled child. In most cases, they'll just give it to the parent that's there. We also are required to have the co-guardians, parents, take an online course with the guardianship group in Austin. And then if they have any elder siblings, then we're required to send the elder sibling a waiver, which basically says that I agree with mom and dad if that's the ones that are being guardian for that, and also saying that they do not require any additional notice from the court. Like every time, if they didn't sign the waiver, every time we would file a document with the court, then we would have to send that document to the elder child. Also, if your young person is in a group home, we have to send the same waiver to a administrator out that. If you're in Harris County, you're going to be also visited by a investigator for the court, and he or she will come out, and we're really doing all this by Zoom now, and talk to you, look at your house, room where your child lives in, and ask her or him if they're able to communicate questions about what they know about guardianship. Also, in the court system, the court will also appoint what we call an attorney ad litem to look after the best interest of your child in court. And that attorney will either come out and speak to you and your child, or do it by Zoom. In most cases, everything's being done by Zoom now, even the court hearings by Zoom. I had one the other day where a father was on a business trip up north, and he was walking in a field with his iPhone, and we're doing the hearing with him. So nowadays, it's in this turmoil that we're in, it's very easy to get a hearing. And that's very helpful in getting parents that may be in different areas in order to come in. Wanted to it's hard to see this, but just wanted to tell you a little bit more about what a physician certificate is and what it's covered. It will need to be signed by a physician or an MD. that particular MD needs to evaluate your child, and then at the same time as the evaluation, as long as it's within 120 days of filing the application, they can sign it. I have had some physicians that have interviewed or evaluated the child 6 months prior to signing, and then that just doesn't work. So I basically tell the parents is when they have the evaluation done on their child, have the physician sign in that point. Basically what this does, it gives the named physician the physical or mental issues that cause a disability in your child, and then it goes through the various things such as cognitive defects, ability to make responsible decisions, developmental ability of the child, and how their disability affects them in everyday life. This is also a very good document that I send parents that are maybe trying to decide on whether guardianship is the best thing to do. And I try to tell my parents is go ahead and fill it out yourself and see what it tells you. And in a lot of situations, it will tell you that you probably do need a guardianship for your child. Who can qualify to be a guardian? Well, of course, they have to be over the age of 18. The ward's parents, the ward is what the court calls your child prior to getting guardianship. I hate that word, but that's what we have to use when we do the court documents. It can be family members, grandparents, or actually a step parent. Now, a step parent can be a guardian if the other biological parent waives his or her rights. A lot of times in divorces, we see a lot of step parents coming in. And if for some reason we can't find the biological parent, then what we have to do is their last known address is we have to serve that last known address by a sheriff's constable with the waiver. And basically we get by in court by just showing proof that the constable went to the last known address, even though they may not be living there anymore. And then we can go forward with the guardianship. A person with a criminal history really cannot be a guardian. It depends on what the criminal history is. If it's happened a long time ago, when the parent was possibly younger, we can get different information from references. If it was a non-violent offense, then in a lot of situations we can go in front of the judge and plead our case that the parent with the criminal history has changed and they're now fit to be a guardian. Won't go through a lot of the others, but with that, but those are the main things that we have to look at in order to qualify for a court guardian. As I mentioned before, we're required by law, and we were doing this before now, but now we're required to law to see if there's any alternatives to guardianship or least restrictive that will allow us not to go through guardianship and take rights away from the young person or elderly person. Some of the main ones, the power of attorney, medical power of attorney, HIPAA release, and we're also going to be talking about supported decision-making agreements. There's quite a few others. Representative payee, that's going to be if you're getting SSI. You can have joint bank accounts and things of that nature. One thing I tell my parents, if they've got parents that maybe are getting a little too old to drive, that are still driving, and the daughter or son does not want to tell their parent they need to stop driving, there's something called the Cates Law. And that's where you can request the state to come in and request a retest your parent, and they won't know that you did that. So that's something that I always try to tell everyone that may be beneficial down the road for you. Statutory power of attorney, basically it's a document that will allow you to do business transactions and financial transactions for your loved one. The main issue involved here is that your loved one, or your young adult with special needs to understand what they're signing. It's a fairly legal document, and a lot of the things, such as they're talking about real property, They're talking about personal property, stocks and bonds, commodity and options. So there's a lot of things that if you don't want to go through guardianship and you're doing the power of attorney, you really need to know whether your child can understand what they're signing. I've done a few of these with children turning 18 with special needs. And basically what I do is I get the young man or young lady in a room by themselves, and I start going through the document with them to see if they understand or kind of understand what they're signing. I have to do this by themselves because if you get mom and dad in there, they're going to look to the left and look to the right when you ask them a question, and then they're going to say, Mom, do I say yes or no here? So, but the main thing is if you go this route, be sure your child is understanding what they're signing, because it doesn't help you or them if they don't. The other thing is medical power of attorney. This will allow you to make medical decisions for your child or your elderly mom and dad, or even your spouse in the event that something happens to them. And these can become active at the time of your signature, which is normally what I tell parents if their child is turning 18, or even if you've got children going to college. You really need to have at minimum, the medical power of attorney, and in a lot of cases, the power of attorney. And you can also, your children can, young adults in college, we can do it when they become incapacitated. So if they're in a wreck or something, heaven forbid, coming to or from college or something, an accident in college, this document will allow you to call the college or call the doctor to find out where they are and how they're doing. Again, this applies to spouses and to our moms and dads if we're lucky to have them still living. And a lot of moms and dads just give it back to each spouse. And they really need to have their children on the medical power of attorney and the power of attorney in order to look after them in case something happens to them as they get older. I had a recent situation a couple of weeks ago where my mother-in-law was in an accident, and luckily my wife had the power of attorney and medical power of attorney. And once she faxed that to the hospital, she was allowed to get on a conference call with her mom and the doctor. And of course, she was sitting in the parking lot because they wouldn't let anybody in the building now with the COVID. But she was able to, with her mom not really understanding what was going on, was able to talk with the doctor and help decide on the best way to go forward with her mom. So it's extremely important. The HIPAA, normally I say HIPAA, and then if you ask me what it stands for, if I hadn't written it down, it's hard to, but it's the Health Insurance Portability and Accountability Act. Well, basically all that says is that this allows you to call the doctor or a nursing home or a hospital and ask for medical records on your loved one. It may be situations where you're helping your mom out and to get medical records for applying for something. And if you didn't have this, she would have to do it herself. So it's very helpful. The last paragraph doesn't have anything to do with medical, but it's something that with all our kids going to college and doing everything by Zoom, and even the teachers taking laptops home and teaching our students with their records on it, there's something called the the Family Educational Rights and Privacy Act, FERPA. And go ahead and Google that and see what that does, because that really affects our students now in school. And then our kids going off with all of this being done by home. One thing I like to go with about now is supported decision-making agreement. As I mentioned in 2015, that came about, and it's a process of supporting your loved one in meetings, or if they're going to buy a car, you can sit down with them at the car dealership and explain to them what's going on. The one good thing about this is that the legislator did not put a level of capacity of the person that's signing this. So this is really a gray area where you may not have a young person that has the capacity to understand the legal ramifications of the power of attorney and medical power of attorney. You may not be ready for them to have a guardianship. So this is one of those where It's in that gray area where you can get by with your child or young adult signing this document and allowing you to sit in on meetings with them. And it also is very helpful if you've in a situation where you can't afford guardianship at this point, and you may be saving money for guardianship to be done, and you don't qualify for like disability rights group and things of that nature, or are in line with the pro bono groups like the Houston Law Association and things of that nature. This will allow you to at least accompany, go with your loved one to the doctor or things of that nature. So I think in that situation, it's an extremely important and helpful document for people. But what it doesn't do is allow you to make decisions for your loved ones. It allows you to assist your loved one in making or giving them the information in order for them to make a decision. Now, I know at the end of the day, you're probably going to be making a decision for your loved one, but from a legal sense, you cannot make decisions, but it is a good document in order to get you in the front door if they're not able to sign a medical power of attorney or power of attorney. So it's in that gray area that I'm so glad that the legislator realized there was that part that they needed to help people out with. This is kind of a redo on what we've talked about. Again, we've mentioned guardianship is not permanent. It can be full or partial. Of those rights that are taken away from your child, we can pick and choose. I have a lot of people that are still allowing their child to vote. I have a few that they're driving and voting. And then I have one or two that they allow them to have marriage. Now, unfortunately, guardianship does not do a few things. Now, it does not allow you to sterilize your loved one if needed without a court order. If your loved one is running off and having sex with someone, it does not allow you to call the police or go get them from that person unless they're in danger. That's the clue here, in danger. Also, they can run away and go stay with someone, and you cannot call the cops or police to go get them unless they're in danger. So just remember that it doesn't, guardianship does not cover the person inside. It covers everything around them and keeping them protected in that way. So in order to get your child back or whatever in situations like I mentioned, they have to be in immediate danger. Again, guardianship is needed when the child turns 18 because he or she is an adult. And it also applies to your parents. If something happens to them where you do not have medical power of attorney or power of attorney on them, and your mom and dad may be both in a nursing home, one could be getting dementia, or one can be incapacitated in the hospital. The only way in Texas that you can pay their bills, go to the doctor if you don't have medical power of attorney and a power of attorney is get guardianship. And that is a process that is, you probably have to go get temporary guardianship in order to get it done, but you still have to go to probate court in front of a judge. So that's why I tell everyone, if there's any way you can get power of attorney and medical power of attorney with your mom and dad, please do so. The other things is that the same thing with HIPAA. And I mentioned this before, a lot of parents do not want to give their rights away. So you can tell them that definitely you have to be incapacitated before I get in your business. The other thing that I've got a number of parents who have adopted people from overseas, and some of these kids have fetal alcohol syndrome, which is a situation where the mom was drinking during gestation and their brain is permanently damaged. And a lot of these kids, they can be fairly high functioning, even with a fairly high IQ at times, but they have extreme anger issues. And a lot of times with them being high functioning, the parents that have adopted them decide not to get, if they have other disabilities, decide not to get guardianship of them and say, well, we'll go ahead and get medical power of attorney and power of attorney. The problem with a medical power of attorney and power of attorney, if you have a child with anger issues or that may get mad at you, is all they have to do is say, nope, it goes away, because they have the right to say that you are no longer my medical power of attorney agent or my power of attorney agent. So if these kids wake up one morning and are mad at mom and dad, then that legal document that you had signed could go away. So I wanted you to be aware of that. I think we have some more time here. I wanted to go over some other possible problems that you may run into. I think I mentioned that if your family members leave money to your child with special needs in their will, and that they have not specified that it goes to a special needs trust, then what we have to do in probate is to go in, hopefully before the person's family, your family member's will is probated, and ask for that to go into a trust. That's called a 1301 trust, a management trust. And unfortunately, most of the courts are either going to put that under court control or put that with a bank. So there's situations like that. If you know any family members that may be giving your child any inheritance that with special needs that may be getting SSI and Medicaid down the road, you may want to set up a special needs trust, or they can set up a special needs trust for your child. A child can have as many third-party special needs trusts as they want. Third party is a trust that is set up by other people's assets going to your child. Now, if someone gives your child something and it's already gone through probate, and then the executor is calling you up saying your child just inherited $500,000, then what possibly they can do if they're over the age of 18, then we can put that into what we call a first party special needs trust, and it won't affect their Medicaid. So, or SSI. So there's different things we have to do. Also, if your parents have set up a 529 college account for your child when he or she was young, and now that they've been diagnosed with special needs and may not be able to go to college, they can actually roll that 529 over to an ABLE account and then be able to spend that on your child. Also, grandparents sometime have set up a UTMA account, which is a Uniform Transfers to Minor Act account. And in that situation, the minor child at age 21 in Texas, it's age 18 in other states, will get all the inheritance. And sometimes when we have that, we try to put that into a first party trust or prior to, excuse me, the child turning 18 or 21 in Texas. I think I've mentioned a parent dies unexpectedly and leaves a life insurance policy to the minor child with special needs, or even any minor child. Then if there's not a trust set up prior to that, then the life insurance company will require the remaining parent to get a guardianship of the estate. Also, if a parent dies unexpectedly without a will, then we have to go through a lot of things about how to separate the estate. And usually at that particular point, we do the 1301 management trust and probate. I want to thank you for your time. If you have any questions, please feel free to email me at boyd@the office. I also have a website that's got a lot of useful resources and information on it. And I also want to introduce you to Team Hanley, my wife and my daughter, Caitlin. They help me at all the resource fairs I go to, and they're really a big help. And it's really a team effort in my law practice. My wife helps a lot with the workings of SSI and Medicaid, because my daughter gets SSI and Medicaid, and it's just a family affair. And we always look forward to telling our story to everyone. Again, thank you everyone for joining me today, and we hope you have a great afternoon. Take care.